Legal and professional standards in archaeology can be different from each other, as can happen in many fields of work. The legal standards are managed by government laws and agencies, while the professional standards are established by a community of working practitioners. In archaeology, the legal aspects are adopted and enforced by a Bureau of Antiquities, a historic preservation office, or another government entity. The legal standards involve laws that protect sites and artifacts, as well as legislation that requires for the sites and artifacts to be documented in a professional manner. The details usually are not mentioned because any singular, strict set of pre-designed procedures inevitably will become irrelevant and ineffective. In the reality of daily work, professional archaeologists need to make choices about how to document a site or an artifact, depending on the location, the represented time period, the cultural context, the scope of archaeological evidence, and the new advancements in scientific techniques and technology. A professional archaeologist should learn how to identify these variables and how to adjust with them while working toward the goal of creating a professional documentary record of the evidence. For these reasons, the legal standards usually avoid constraining the choices of professional workers, and instead they may refer to a certification or license for professionals to be eligible to work in a specific field. The process, however, usually is managed by an independent society of archaeology or another non-government body, separately from the government agency that enforces the legal standards. Ideally, this separation can reduce the opportunities for a single person or group to make poor decisions or to engage in various schemes of corruption or collusion. A legal standard might call for the recording of maps and photographs at a scale that shows the salient features of a site or artifact. The legal standard does not need to mention the details of a scale bar reference, a choice of mapping coordinate system, or the megapixels of a digital camera sensor. Likewise, the legal standards do not need to mention the use of a particular choice of any hardware or software. If the legal standards do mention all of these details, then several problems will occur because the professional workers would be disallowed from making their own choices about how to perform the work. More effectively, the legal standards could call for maps that show a location accurately enough to situate it in its surroundings, as well as images that represent what a site looks like in enough detail to convey the appearance and context. Toward meeting those legal standards, a professional archaeologist needs to make decisions that meet the expectations of professional work. The details can be considerably different from one instance to another, and the supporting technology has been changing rapidly. Similar logic applies in other aspects of archaeological work. For instance, the legal standards could require excavations sufficient to document the layers of a site, while the professional standards could involve the details of how to distinguish each layer, how to obtain dating references for those layers, and how to justify the ending of an excavation at a depth that certainly predated any human presence. Serious problems would occur if the legal standards call for excavating only 50 centimeters deep, while the professional standards already have established that site layers could be much deeper and older. Legal and professional standards involve many issues, and they are greatly variable from one region to another. The most updated information should be available at a relevant government office, museum, or university. For now, I hope that I have offered a reasonable sense of how to approach these issues in general toward understanding whatever specific situation that you might encounter. Thank you for watching here. I will see you in the next video.